A 19-year-old woman, had consensual sexual intercourse with B, a 17-year-old boy. The woman is older. She is 19-year-old. The boy is younger, 17-year-old. Now, in this case, B's parents, that is the boy's parents, found out, and they approached the police for registration of an FIR for statutory rape. The police officer insisted that no offence had been made out. Was it a case of rape? Rape of a boy by a woman? Smita says no. Why? You say no offence is made out? Apart from rape? Yes, rape can be only against a woman. It can be committed only by a man. All right, let's see. That is correct. But there are options which involve the Protection of Children from Sexual Offences Act also. The first option is, yes, Shruti is talking about POCSO, yes. And is the woman liable under POCSO? That will be a very important aspect. And JJ Act does not create offences, but POCSO, yes. Let's see. First option is the police officer is partly right and partly wrong. This is not an offence of statutory rape, punishable under the IPC, but the offence of penetrative sexual assault, punishable under the Protection of Children from Sexual Offences POCSO Act. So the first option says that though it is not a statutory rape under IPC, but it is still an offence of penetrative sexual offence under the POCSO. The second option is the police officer is right. Rape law is gender specific. Only a woman can be a victim of rape and not a man, and so no offence is made out. The third option is the police officer is wrong. This crime is punishable under the JJ Act, and fourthly, none of the above. So let's start our answer with section 375 IPC. Whether it is statutory rape or not, clear from here, a man is said to commit rape. So only a man can commit rape. There is no doubt about the person who can commit a rape, and therefore a woman cannot commit a rape. 375 goes out. We are not concerned with 375. But what about POCSO? We are concerned here with section 3 of the POCSO, penetrative sexual assault. Here it says a person is said to commit penetrative sexual assault. It's not, the word here is not man, it is a person, which means even a woman can be said to commit penetrative sexual assault if the conditions are satisfied. Can it be? What is your take? IUC says under POCSO, she may be liable. She may be liable or she is liable. Here, a woman is having sexual intercourse with a boy who is under 18 years of age, which means he is a child. Smita says, yes, woman can be liable under POCSO. Under which clause? Section 3, of course. Not under clause A. He penetrates his penis. Obviously, it cannot apply to a woman. So, clause A will not be applicable. So, let's see whether other clauses of section 3 can be applicable. Though here the word person is mentioned, but let's see whether the clauses are applicable. A is not applicable. What about B? Where the person, the accused person, inserts any object or a part of the body into the vagina, urethra or anus of the child. So it includes, this child can be a boy also, and the accused can be a woman, because here we are talking of inserting an object or part of the body like finger. Anus is also one of the parts of the body which may be involved. So can we say that, but here it is, in some cases it can be applicable. We will see whether in this case it will be applicable or not. Clause C, he manipulates any part of the body. He means C also. Manipulates any part of the body of the child so as to cause penetration into the vagina, urethra, anus, or any part of the body of the child. And lastly, if he or she applies his mouth to the penis, vagina. Here both words have been used, both the terms have been used, which means the child, the abused child can be a boy, it can be a girl also. Anus, urethra are also concerned. So yes, POCSO, Section 3, Clause B, Clause D, etc. can be applicable. He includes a female also, all right, agreed. Now, see the facts of the case again. Can we say that Section 3 POCSO Act will be applicable? Is it a case of penetrative sexual assault by a woman on a boy? Shruti says penetration. Penetration may be of finger also. Insertion of a part of the body, a finger. And the part of the child may be anus also. So yes, boy is also included here. But what is the accusation? Accusation is not that the woman inserted her finger into the anus of the child. Yes, then it is penetrative sexual assault. But the accusation is that she had sexual intercourse with the boy. She had sexual intercourse with the boy, isn't it? Let's go back to the facts. A 19-year-old woman had consensual sexual intercourse with B, a 17-year-old boy. So, as far as the accused woman is concerned, she did not insert any object into any part of the body of the boy. It's a natural sexual intercourse, heterosexual intercourse, and the penetration is by the side of the boy, not from the side of the woman. No insertion of any object by the woman, and clearly section 3 of POCSO Act will not be applicable. As far as this case is concerned, it's a natural sexual intercourse, and therefore section 3 POCSO Act is not applicable. 375 IPC is obviously not applicable. No offense is made out, and we can say that what is the option now? Correct option? What should be the correct option? D. What about B? The police officer is right. Rape law is gender specific. Only a woman can be a victim of rape, not a man. So no offense is made out. You can even speak out on the audio. IUC also says D. Yes, a child is involved. A person under 18 years of age, that means a child is involved in this case. But we found that even under POCSO, the offense is not made out. What was the question, by the way? To decide whether option B will be applicable or option D will be the correct option, let's once again go to the facts of the case. They approached the police for registration of an FIR for statutory rape. The question is very simple. We are going into so many other aspects just to understand the concept, but as far as the question is concerned, we need not go into the aspects of POCSO. Here, the case is for registration of an FIR for statutory rape. Statutory rape. And the police officer insisted that no offense had been made out. Obviously, it is not a case of statutory rape under any circumstances. So we will say the police officer is right. Rape law is gender specific. Only a woman can be a victim of rape, not a man. No offense is made out. The FIR was for statutory rape only. It was The complaint was not under the POCSO Act. The complaint was under IPC. And the police officer said it's not a case of statutory rape. Can we say that the police officer is right? Option B. Of course, D could also be the answer if the question were worded in a different way. But the way the question is worded, we have to decide which will be a better option. Okay. So you have to choose between B and D. A is not correct because penetrative sexual assault is not established. C is also not correct because JJ, it's not punishable under JJ Act. So either B or D. And yes, in my view also, like Shruti, I would say that option B would be better as far as the way the question has been framed. So it always depends upon the facts and the way the question is framed. Your answer, before answering, please see carefully the way the question is framed.